Mr. Premier?
6 very brief comments in reply, if I may, please, Chair. The first one just relates to timing. I'm surprised to hear my learned friend complain about the fact that the 12th of August gave them insufficient time, whereas in Chair's original ruling from the 29th of July, had Mr. Karim participated in the independent medical examination, that report was always going to be delivered by the 12th of August. And so to latch on to the date...
That was not Mr. Karim's doctor's report.
Correct. Correct.
So I don't get your point.
The point is simply to say that the 12th of August was always a line in the sand that the commissioners had itself identified that the status of Mr. Karim would be known or not known, even flowing from the independent medical exam report.
I still don't get the point. You're talking about a different report, and the report in the ruling was to have been a different report. So I just don't get your point.
Correct.
At all.
All I'm saying is that, of course, the report was going to be different. That report was going to be pursuant to the independent medical exam. I'm not quibbling with that at all. But what that report would have done is it would have clarified Mr. Karim's status to participate in the commission by the 14th on the 12th in any event, because he would either be excused as a consequence of that report delivered on the 12th.
Ms. Hassim is making a different point. She's saying they were not given sufficient time to decide what to do after a different report. Not the report that was expected. A different report was given at the 11th hour. That's a different point altogether.
I'm willing to accept that, and I'll come back to that point in comment number 5, if I can, about what the true status of the cooperation with the Commission has been. But if we put aside the 12th August date for the time being, can I please give you 2 references to the medical report itself, if I may? The first one comes from paginated page 220, under the heading, "The Ruling and Attempts to Obtain Mr. Karim's Decision." And what is listed at paragraph 15.3 all the way up to paragraph 15.10 on paginated page 222 is a full account of what happened regarding the ability to produce this report any sooner. And in particular, in addition to that, I'd point the Commissioner's attention to paginated page 225 at paragraph 19.2, which talks about, and how you read this with the greatest of respect is you read those paragraphs, which is the chronology paragraphs, side by side with 19.2 on paginated page 225, which talks about a medical incident which happened on the 11th of August in the morning. So the day before the report was written and tendered to the Commission, there was a medical incident which was nonetheless reported to the Commission, which impacts and explains perhaps why this report was only given when it was given. I accept the criticism might be that it should have been sooner, or it could have been sooner, but the objective evidence in front of the Commission accounts for that entire timeline, including dealing with the difficulties in obtaining instructions. That's point number 1, Chair. Point number 2, I'm not going to deal with this in any great length because Chair asked my learned friend Ms. Hassim the correct question we submit, which is that when the outings, and I'm using that in inverted commas because they're not outings, there is a clinical explanation for that, and the Commission has the medical report in front of it. But let's use that term, even though it carries a certain connotation.
Maybe it doesn't take us anywhere, but
I think Chair has the point.
I'm interested to know what your idea of outing is when you say outings, but these are not outings. From where I'm sitting, they appear to have been outings.
Be that as it may, so the point is to put 2 is to say, even if we accept, and I respectfully don't accept, but I accept what Chair posits to me, that they appear to be outings, even if we accept that that's the nomenclature, it's not to look at that in isolation from the medical explanation which has already been provided. That's the first point. The second point is to say, with the greatest of respect, that the criticism, and I'm not sure if it is a direct criticism or it's an indirect criticism, that those outings, in inverted commas, are not being dealt with in the latest medical report, is also because that represents a shifting of the goalpost. This medical report, which is now in front of the Commission, explains in particular what happened after Chair's ruling on the 29th of July and what was undertaken or not undertaken in that regard, and to the extent then there are references to historical facts that's also dealt with in this report, and those 7 or 6 other medical reports which have historically been tabled haven't been challenged in front of the Commission, and they stand as an explanation for those outings,
you see,
one way or another.
Last time, and I will repeat even now, last time when you made a similar point about these reports not being challenged, I said to you, how do you expect them to be challenged when Mr. Karim is resisting, strenuously so, to be examined by somebody who can actually challenge those reports? So it's a non-starter for you to talk about a lack of challenge.
That's
complete non-starter.
I respectfully disagree with you for 3 reasons, and this is my third comment. In the first instance, the doctor has himself made himself available on more than one occasion to the Commission.
It's not the doctor that the Commission wants to have assessed. It's not the doctor.
Be that as it may, it's a less intrusive means that's available to the Commission in circumstances where the purpose of the examination is to run a parallel process to verify those clinical opinions. That's the purpose of getting the patient into a voluntary medical examination. The point I'm making is that the doctor...
I'll listen to the rest of your rebuttals, because you say you disagree with me, and I think you said on 3 bases.
Yes.
So the first one, I do not accept at all. You may continue arguing on it, or you may proceed to number 2 and number 3.
No, I won't. It's on the record, and that's sufficient for my purposes.
Okay.
The doctor's made himself available. Nobody's chosen to do anything about that.
Nobody wanted to assess the doctor. So
no, but
may I finish?
I apologize, Chair.
That's simply not an answer to my point.
With all due respect, though, I think we're speaking cross purposes, because what Chair is saying...
We are not. I understand you perfectly, and I'm sure that you too understand me. To counter the question whether Mr. Karim is indeed unable to come to this commission, the Commission has said it wants to have him assessed by an independent specialist. He has refused that should be done. That's the assessment that the Commission wants to have. It's not an assessment of Mr. Karim's specialist. That's the simple point I'm making.
Yes.
And for Mr. Karim to offer us his specialist, that does not assist. In fact, that actually takes us to what courts always say, the hired gun principle. Because from where we are sitting, we do not consider Mr. Karim's doctor to be an objective expert. He is an expert that's closely associated with Mr. Karim, and who, from where we are sitting, unless we get another opinion, appears to us to be pushing Mr. Karim's story. So very close to, if not analogous to, what courts have referred to as a hired gun. In this sense, if a court wants to get an objective view, it will want to get someone who is independent, as opposed to someone who's closely associated with the person concerned. And this is exactly what we have here. A medical specialist who has been treating Mr. Karim for this lengthy period, and who on certain facts appears to have shifted the goalposts. And why do I say so? I say so on the basis of that paragraph that I referred to during the postponement application. In fact, I referred you to more than one. There are the paragraphs where he changes his story on factual issues, not issues related to Mr. Karim's condition, on factual issues. He changes his story because he said a patient can only go out of the facility, only, underline only, if I allow them to go out. But once we got the Woolworths and the Kauai visits, all of a sudden, the doctor now changes tack and says, oh no, actually, even nurses do allow patients out. So from where we are sitting, those are indications that this is a doctor who has so aligned himself with Mr. Karim that sitting, I'm not saying he's lying. All I'm saying is, sitting where we are sitting, we just cannot accept what he says. We do want to have an independent assessment, which we do not have and which we will obviously never have, because this same doctor strenuously resists that, and it is best known to him why he does so. Of course, he does explain in the reports that he has given. But from where we are sitting, we cannot just accept that. So it is on that basis that I say, in accordance with jurisprudential authority, his position is very much analogous to that of a hired gun. And it's in those instances that courts always insist on someone who is independent, someone who is objective, but as I say, we are not going to hold our breath on in that regard. We are not going to have such an independent assessment. So I say again to you, you cannot say that, you cannot respond to my point about the lack of contradiction in the manner in which you do, because that opportunity has been refused. I know I've said a lot, but respond anyhow you want to.
No, I'm indebted for the indulgence to respond. I am cautious, however, that I'm not going to take us in a circle regarding this contention, because I've understood what Chair said. I disagree with Chair's characterizations in two respects in that regard. And in fact, I think for the first time, the criticism that Chair has posited regarding the doctor has done two things with the greatest of respect. The first one is it's clarified what the actual concern is regarding the doctor's objectivity. That was the word that Chair used. And also to set out the justification as to why the independent medical exam is potentially needed because of that concern on objectivity. May I say two things in response to that, please, Chair? The first one is, I think, and I say this with all due respect, and I hope this doesn't come across as being impertinent. I think, Chair, you've actually articulated why the doctor is more necessary, not less necessary, if his objectivity is in doubt. Because if his objectivity is in doubt, which is not necessarily the same regarding the rightness or otherwise of his clinical conclusions, then it's him as the doctor offering that evidence who has to be impugned so as to demonstrate that his objectivity is justifiably in doubt, And whereafter his objectivity is justifiably in doubt, then the gateway mechanism to the medical examination is opened. So where I respectfully disagree with the chair is I say the conflation, and I use that word respectfully, I obviously don't mean it in a personal way, but the conflation that chair has made in positing the reason for the independent medical exam to me is an objectivity issue. But if that's an objectivity issue, an independent medical exam may come to the same conclusion that this doctor has, but that doesn't do anything in respect of his objectivity or otherwise. And what I would respectfully say, and what courts do all the time, is where an independent expert is used by one side or another as to evidential issues and legal conclusions, then you don't go and bypass that particular expert to go to the underlying individual or evidence. You impugn that expert. You impugn his objectivity, whether by demonstrating he's a liar, whether by introducing your own rebuttal expert witness, or so on. That's the ordinary mechanisms of litigation. And so the conflation that I'm respectfully contending for is...
May I just say, I'm not conflating anything. We don't have to have only one reason. The reason may one be the commission wants to be sure that there isn't a basis for not accepting what Mr. Karim's doctor says.
Yeah.
That's one. And two, I'm then saying the doctor appears even on factual issues to have so associated with Mr. Karim's case, let me call it that is additional to the first reason as to why the commission would want to satisfy itself. So the original reason stays, it remains. So what you are addressing does not suddenly become the reason.
No.
Yes.
Thank you, Chair. Could I be cheeky?
And sorry. And also I'm not altogether sure that I agree with you with this staggered approach on how one deals with expert evidence. I don't agree with you. You may upfront just say, I want to establish whether this should not be questioned by, at the outset, having an independent assessment. So your staggered approach, I just don't agree with. Yeah, you may respond.
Chair, I still have my second reason I'm going to come to. I'll come to that in a moment. I'm just on the objectivity leg if I can. On the issue of the reason, I'm going to be a bit cheeky and say it can be any reason to doubt the objectivity. It doesn't matter what the reason is. My fundamental point, and I know Chair says he doesn't conflate anything, I'm going to step away from that word. My simple point then is to say that if whatever your reason is to doubt the objectivity of the expert put up, in the particular instance of a medical examination, you cannot leapfrog that evidence and that practitioner to go directly to the patient.
Why not?
Because that's going to be my second response to you, because then that takes us into the V-raise issue and whether or not you have the power to do that in the first place. So what I'm saying to you, Chair, in response to those three things you said about it could be any reason he's associated himself with the case, and that's the basis for the concerns about and that you don't agree with the staggered approach that we're talking about. I'm willing to accept that, but I respectfully disagree with you, because not only does it leapfrog what we submit respectfully to you is the correct sequence having regard to what happens in the High Court, we also say that there's a V-raise challenge potentially to the extent to which you can make such an order and compel such examinations and proceedings.
There's no compulsion, and I'm not even sure that the virus issue that you say you are going to argue, and on the basis of which you are talking leapfrogging, even arises. There's no compulsion. It says, I think
It says voluntarily.
Exactly.
No.
So if he chooses not to go, nobody will force him.
Yes.
So the virus issue really does not arise at all. I know I've gone to your next point, which you have not argued, but because you've already mentioned it, nothing stops me from dealing with it. So this virus issue, from where I'm sitting, simply does not arise at all. So there's no leapfrogging at all.
Well, with all due respect, I think that it takes, and again, you would have received the highlighted transcript, which we say bears out our recollection of events from the last occasion, and I'm not going to revisit that. All I'm going to say is that takes us to the exact point that we debated there, which is, if it is truly voluntary, then no negative consequence can attach on the election of the voluntary choice. And that's where Chair and I think we agreed that we were ad idem in that regard, and then Chair moved on to, but what are the consequences if he chooses not to? And then are those subject to some or other bar? And I said to Chair, no, that's the ordinary consequence of how you determine evidence. So the point I'm making about the voluntariness of the proceeding and how it relates to the virus challenge is the degree to which the non-election to participate for the reasons in the medical report, which I would call gently a supervening medical impossibility, but be that as it may. If Chair is, and I think we're ad idem on this actually, if Chair is not going to attach any punitive consequence or coercive consequence to the election in the voluntary scenario.
Let me upfront tell you what I am, or rather what I think the Commission should do. The Commission is minded to refer Mr. Karim for a criminal process. What the relevant authorities do in that regard is for them to decide whether it's taken to the South African Police Service for them to see whether they can lay charges, or the National Prosecuting Authority for it to see whether to prosecute. That's their decision. That is what the Commission, as we are sitting here, is minded to do.
Yes.
So that will not be coercion by the Commission as such. It will be those functionaries who have the power to do whatever is within their remit to decide or do.
Correct.
That's what we are minded to do, so that you are not arguing in the dark.
Yes.
Let me upfront tell you what we are minded to do.
No, I'll deal with that. That's my last point, which I'll deal with about any such referral. So I'll come to that if I may. I just want to deal with this voluntary nature of the choice that was made. And I want to clarify that I was not suggesting that the voluntary choice given in paragraph 2 of the order was not a voluntary choice, and that was somehow coercive or involuntary or anything of the kind. I was simply reminding the commissioners about that voluntary characterization, because some of the language that was used about not subjecting himself to a medical examination was, to my mind at least, and if this is wrong, I accept that it's wrong, was going into the territory of adverse consequence for that. And that's why I was just reminding us about the debate we had about voluntariness.
I thought in the end, you and I agreed previously when we debated that point. I said to you, I was not talking about adverse consequences that would arise purely from the fact of failing to testify.
Then we're ad idem.
We were even then.
And we're still ad idem now.
I think you actually said so.
Yes, we're still ad idem. That's the only point I was making. That's the only point I was making.
You may continue then.
Thank you. My fourth comment. On this issue about obtaining, because Ms. Hassim said something to the effect about the time consequence, only receiving it on the 12th, that there's limited time to receive their own expert rebuttal evidence, for lack of a better phrase, to obtain their own instructions regarding that and their next steps. All I'm going to say on that regard, in that regard, Chair, and not to reopen something we've moved beyond, is that's also part and parcel of the tender that was made as to why the doctor would make himself available. Because you'd remember the doctor didn't only say, obviously subject to in camera because it's about medical information, I'll come here and opine to you. Express reference was made about cross-examining him and so on. So to the extent that there's been any prejudice caused to the Commission as a result of the late receipt of that report, all of those mechanisms which were tendered previously, and in fact the doctor tenders once again in the latest medical report, is available to the Commission. And if the Commission wants to do anything with that, their own witnesses and follow up however they want to, will be in the Commission's hands in that regard. But I must place that on the record, because any suggestion that my client is just running away from accountability and not himself, through his family and medical representatives, doing whatever he can to cooperate with the Commission in the circumstances in which he finds himself, needs to be responded to, and I won't take it further than that. Those mechanisms are there, and if they're going to be used, we'll cooperate to the extent that we can.
If one were to use the analogy of civil proceedings, what normally happens, yes, what you say does happen if one side, for whatever reason, does not have an expert.
Yep.
But what usually happens is for the opposing side to have their expert consult with the plaintiff.
Yes.
And to then prepare their
Yes.
opposing report.
Yes.
And then the two experts get called.
Yes.
So now what we have here, there's resistance to that assessment, and what, I'm the one who should now read and comment on your reaction.
Yes, indeed. My shock and horror.
Now, what's happening here is, in addition to that resistance, the one doctor offers himself to appear before this commission and to be subjected to whatever questioning. So it's rather an odd one. But as I said right at the beginning of what I'm saying now, it does happen on the odd occasion that there may be one expert, but the norm is to have two opposing experts,
Yes.
both experts having examined
Yes.
the patient, done their own assessments, prepared individual reports on that patient. Yeah. Now let's hear you on that reaction.
I'm not sure I agree on where you ended, Chair, which is to say that both experts examine the patient and then give the differing rebuttal evidence. And the reason I say that is, obviously we're not in Rule 36 territory about the assessment of damage from medical injury or whatever the case might be. And also because it's a voluntary examination and it can't be compelled, that's why I disagree with the characterization in the way of this expert rebuttal process.
I'm not in the realm of the virus issue.
Agreed.
I'm
Neither am
not
I.
there at all.
Agreed. Neither
I'm
am I.
just at the level of how evidence of this nature is ordinarily dealt with, how it plays itself out in a court environment. That's
Yeah.
all I'm debating.
We're in the same place.
Yeah,
I'm not in the
yes.
V-raise.
So the voluntariness,
Yes, yes.
compulsion, and so on does not arise
No.
in that context.
Agreed. I was just saying that those are the important context issues which need
I've not forgotten
to be
them.
considered.
I've not forgotten
I'm
them.
indebted. So the point that I would make regarding that process that Chair posits to me about rebuttal witnesses and contrasting experts, and Chair says is in the ordinary course, that's what I was saying a bit earlier about less intrusive means about the available to the Commission. If the doctor's evidence, which Mr. Karim's doctor's evidence, which relies on his objectivity, is in dispute. And that's the basis through which it can be impugned as a less intrusive means without taking us into a V-Rays problem about is this voluntary examination voluntary or not voluntary. So I would respectfully say that what Chair has posited to me is the exact thing that the doctor has been tendering, and I think, in fact, in correspondence, Mr. Karim's own attorney said, let's do it this way so that you can get the degree of satisfaction that you require. Now, I understand, Chair, to say that, that might be how it's ordinarily done in the High Court and maybe it's different in the Commission or whatever. All I'm saying is that's a process that's available, and if my learned friend contends that there's prejudice suffered as a result of the lateness of the report, whatever unfolds as a result, now that they have the report in their possession will unfold, and we'll deal with it as we need to deal with it. But the fact that the mechanism is available, which we on behalf of Mr. Karim proactively offered, and Chair himself now recognizes as a possible mechanism. I'm not saying Chair says it's right or correct or good or whatever. I'm just saying it's in the realm of possibility.
Which mechanism? Are you talking about the doctor?
The rebuttal witness mechanism that Chair started talking about. I'm saying that the fact that that mechanism exists in the possibility of options in next steps as a less intrusive means is as far as I'll take it. The fact that there are ways to obtain the Commission's own assessment about objectivity or otherwise
that assessment
without the medical examination.
No. I was talking pursuant to a medical examination.
But you remember
and that's what Mr. Karim, through his doctor, is resisting. So I don't get you.
No. Remember, I said that was a contextual issue, that the voluntary exam is voluntary, and then Chair responded and said, but we're not there because that's a virus issue and we're not talking about that.
There can't be a rebuttal witness in the sense I was talking about if there has not been an assessment by that doctor.
And that's where I said I respectfully disagreed with that. Remember, that's the first thing I said, is I disagreed with that characterization at the beginning.
I just wanted to make sure, that because it seems you misunderstood me.
I didn't misunderstand.
I was talking rebuttal after an assessment by that rebutting doctor.
And I immediately responded and said, I'm not sure I agree with you in that regard.
Can you move on to your next point?
No, that's fine.
Please?
I was just setting out then the basis for my disagreement with you, Chair, respectfully, about how that mechanism is going to work. I don't have to take it further.
We can't force him, we agreed, and which is why I'm talking about the criminal process the Commission is minded
Exactly
to.
the point, Chair.
Yes.
Exactly the point, Chair. So that is available. May I just then speak to what the Commission says is the way forward? Chair, you'll remember that in its letter, I'm going to read from page 119 of the correspondence bundle, but as far back as the 24th of June 2026, this is the Commission's letter to my attorneys. At paragraph 12 is exactly what the Commission says today is the way forward, obviating the need for a medical exam.
Evidence leaders, Mr.
Evidence
Private,
leader,
don't confuse.
I apologize.
Don't confuse what the evidence leaders say with what the Commission.
I apologize. The evidence leaders, and I don't want it to sound like I'm
They
now
say
personalizing
in the circumstances, the evidence leaders will proceed as follows.
Yes. So, and that was, you'll remember that was on the 24th of June, and then I think we were in front of you. Was it the 1st of July? And then there was an exchange of correspondence, and this medical exam issue arose after this letter. But in response to that particular letter at paragraph 12, came our letter, which starts at page 121, which says, yes, if that's what you want to do, that's what you must do. And so insofar as Ms. Hassim says today, the evidence leader says today, that this is the position of the Commission, and we'll...
Of the evidence
leaders, I apologize. Ms. Hassim says that this is the position of the evidence leaders. We understood that to always be the case from that page previously, and we've never taken objection to that, which is why, Chair, you'll remember in that debate that we had, I think, that the transcript refers to, when you and I were discussing the adverse findings that were to be made, my response to you was that, yes, that's the ordinary way in which evidence will be dealt with, and if it's unanswered, you'll draw the appropriate inference, you'll draw the appropriate credibility finding, and that's the risk that my client was always subjected to, and that's the consequence he must face. So if that's the Commission's attitude today, consistent with what they previously said on the 24th of June, in that debate with you, Chair, you'd remember I said I can't commit my client to a position, but I explicitly said to you I could not fault that that's the end point we'd come to. So to the extent that's the evidence leader's, Commissioner Kamalo, to the extent that's the evidence leader's position in front of you today, I accept that position. In fact, and not to be flippant about it, we were already here a month and a half ago, and only as a result of the Commission's extension and the possibility of a medical exam did all of these issues arise all over again. So in fact, we're now going back to the position that we were in late June, and with all due respect, the Commission, but also sometimes the evidence leaders complain that the Commission is running out of time and there's no guarantee of an extension. So we're back to where we were on the 24th of June. The Commission and or evidence leaders will do what they do, and we'll deal with the consequences. Lastly, Chair, on the issue of the possible preferred recommendation of criminal sanction, whilst you've got that the letter I referred you to starting at 121 in front of you, it's just a few pages on from the Commission's letter at paragraph 12 that we were dealing with. If you could please go to paginated page
124?
124, yes, indeed. That's the request.
Again, Commissioner Kumalo.
Thank you, Chair. I'm indebted. Particularly paragraph 11. If such a recommendation is going to be made, then on that specific question about whether criminal charges should be recommended or not recommended, all I'll say is that our client, as far back as the 24th of June, asked that if such a referral was going or recommendation was going to be made, that he be given the chance to address specifically that referral decision, consistent with authorities like Dupria and so on, and also because that's an Audi issue, we say respectfully, and particularly to place in doubt the question of willfulness and whether or not such criminal charge is competent and viable as against my client. However,
aren't those issues, that is the issues of willfulness and so on, issues that should actually arise before the relevant criminal authorities, if that referral does not get killed at the level of SAPS or at the level of the NPA, they may then be dealt with by the criminal court. So I'm not sure I get your point.
What I was going to say, and then rightfully I showed deference to the chair, is that on that particular point about Audi in front of you before the recommendation, I was going to say that's not the hill I'm going to die on, because it might be correct that you can make the recommendation being recommendatory in nature without ticking the box of direct external legal effect as well as adverse consequence, that you even owe us the right of Audi at that stage, because the correct decision-making functionary is where we'd have the ability to make those representations anyway. So what I was going to say to Chair is that the request is in front of you. You may choose to say no, which is fine. I'm just saying that the request is there. That's all I have to say.
We are all here now. Make whatever submissions you have in mind in this regard, so that we are done. It's done and over with.
Thank you, Chair. May I just make 3 submissions in this regard then? Number one, the test would be willfulness for any such breach or non-compliance. We say that the threshold is not met, having regard to the medical evidence that is in front of you, and which is unchallenged, and I know that that's sensitive territory, so I tread lightly. That's the first point.